and partner and primarily leads to the firm's IPR and corporate practice. After graduating in 2011 from the prestigious Government College of Mumbai, Jasneet worked with the IPR divisions of two leading law firms in Delhi before shifting her practice to Chandigarh, and later co-founded Just IP in 2019, a specialized law firm dealing primarily with IPR, arbitration, company and corporate laws. She is also an avid writer and has authored several articles on IPR for various law journals and blogs. With more than 12 years of experience, Jasneet also successfully represented clients in high courts, district courts and various other judicial forums and tribunals, including Armed Forces Tribunal, National Company Law Tribunal, Real Estate Regulatory Authority, District and State Consumer Commissions, etc. She offers advisory on clients spanning across industries, including media and entertainment, houses, software, pharmaceuticals, sports, immigration, among many others on key issues relating to intellectual property rights, arbitration and corporate law. So I heartily welcome Madam Jasneet. She will come to the dais and share her very valuable ideas. Before inviting, I would request, I would be very thankful to Mr. Pankaj Mohanty, who has come from our Chandigarh being High Court unit, and the officers of the IFOs and other military divisions, and President of Adhivakta Parishad Chandigarh, Armed Forces Tribunal, Unit Chandigarh, Mr. Sharma. Thank you.
There is one announcement.
There's a small announcement from today onwards. We will be going live on YouTube, and this
And also we are live.
we are live. Thank you.
Thank you everyone. Thank you ma'am for the introduction. It feels very special because I'm very associated with this bar and this tribunal, also having practiced here for many years and still practicing. So I would like to keep this session very informal and interactive. And the topic for today is very, very different from the topic that you all as lawyers usually deal with on a day-to-day basis, which is primarily relating to service matters and military law and armed forces related matters. So today we'll be talking about intellectual property rights and the law relating to these intellectual property rights. So IPR, I'm not sure how many of you have read about or how many of you are well versed with it. So we will just do a very brief introduction from everybody. I'd like somebody from the bar, from the audience to, if you know what IPR refers to, briefly also, if anybody would want to just share their idea, give an example. Is there anyone who would like to just give an example also?
Property rights, no IPR.
IPR, okay. So as sir rightly said, that most of us are well versed with property laws and rights relating to immovable properties and all. So what is intellectual property and how is it different from normal property laws like IPR? How is it different from say an immovable property? So let's get to the name itself. When we say property, what does property actually even mean? Property basically means, if you do a simple Google search, property means a thing or any object that belongs to somebody, right? So when we say an immovable property, it generally denotes a land, a plot, a house, a building, something like that. So again, when we say an immovable property, it belongs to somebody. There is a title involved, there is a question of ownership involved in that. Now coming to intellectual property. So from the name itself, you can gather that this has got something to do with mind, something to do with intellect, right? So anything that is a creation of your mind, anything that originates from your ideas, from your intellectual ability, that object, whatever that idea is or whatever you are creating, that becomes a property also. So that is called an intellectual property, and all rights that flow from that are referred to as intellectual property rights. So I have with me in my team Himani and Apurva. They are also practicing IPR lawyers. They will share with you a handout that we've got for you. This is basically an extract of a detailed note prepared by Justice Pratibha Singh. She is the sitting judge of the Delhi High Court. But most of you may not know that when she was practicing as a lawyer, she was an IPR, she was considered to be an IPR expert. So she holds a lot of expertise in IPR law, and as a judge also she deals with a lot of IP matters. So this is a note that she had prepared for the Chandigarh Judicial Academy on IPR. So we thought we'll take some extracts from that note and bring it to you, share it with you, so that it will be easy for you to comprehend, and this is something you can take back with you to your offices and refer to it whenever you feel like from time to time. So as we discussed, intellectual property basically fundamentally means something that is created from your intellectual ability, something that comes from your mind. So now why are these things also important to protect? These things are also important to protect because these are somebody's ideas, they are your creation, they are an original work, and most of these ideas come from genius minds also. So these require protection, and at the same time, they also require enforceability from time to time. So we'll discuss all of this as we go ahead. But I just wanted to start with a background as to what intellectual property is. Now, I think it will also be helpful if we discuss some examples. So if you see the note, if you see the second page of the note, you can see, an example. Now, instead of giving you different examples for different IP, what I'll do is I'll show you one device, and from that, I'll explain, how I'll try and demonstrate IPR from that one device. So we have with us a phone, okay? Now this is an iPhone. Most of you can recognize this, okay? Now, one phone in itself can have multiple intellectual property rights. Okay, so there is a technology in this phone. That technology comprises of patent. That is a patented technology. What are patents we'll discuss. And then you can see this Apple device at the back of the phone, right? This is a logo owned by iPhone. Over a period of time and with several years of usage, this logo has become a big brand, right? So this logo in itself is a trademark owned by Apple. Okay, so we've already seen that there are two intellectual property in just one object. Now I will also tell you how there is another intellectual property in this one object, which is this unique design. Okay, so the design of the phone, it has these specific curves, right? And there is a specific dimension of the phone. On the edge also you can see. So this design is also unique, and this is again owned by Apple. So we've seen that in one object, there can be multiple innovations, there can be multiple creations of the mind. And it's basically a bundle. So when we talk of intellectual property rights, we refer to a bundle of rights encompassed in maybe one object, as we've just discussed. And this is again reflected in the note also that I've shared with you. The fourth category, the fourth example that I can give you from this one phone is also the softwares, the mobile applications that are running in this phone, right? So all of you look at different apps. You are using a WhatsApp, you are using social media apps. You know, these are all applications that can be protected by way of copyright. So again, a bundle of rights involved in just one object, okay? If you see the third page of the notes that we just handed over, again, these are some examples you can see. You can see some trademarks, you can see some logos, some brands there. You can also see some sarees. These are Banarasi sarees. Okay? So Banarasi has become a geographical indication. Banarasi has become so famous that anything which has a Banarasi fabric or a print, it denotes that this has originated from Banaras. So, an indication of a geographical area. If there is a product, if there is a pattern which indicates the geographical area of, it denotes a geographical area, that is referred to as a geographical indication. And that can also be protected. So no other company, no other country also in fact can use the Banarasi pattern and say that it has come from that company. That cannot be. A Banarasi pattern will always be indicative of Banaras as the geographical area. So this is again another example. Now you can see the Nike tick mark. So the tick mark over a period of time has itself become so popular by way of usage that it okay. So these small things, these small signs, these are all indications, these are all brands that have with time, they have been created by mind. It was somebody's intellectual idea to use this tick mark for the company Nike, for their clothing, for their shoes, for their accessories. So again, this is an intellectual property right which was created, and it is now, a small tick mark is also now so big and so well known in the entire world that it requires protection so that nobody else can copy it. So again, these are some examples which will help you understand about things that we use in day-to-day life, how IP is all around us, The fourth page, if you see, it's a car, it's a vehicle. Again, one object indicating so many different forms of intellectual property. The automobile in itself contains various technologies, So all those technologies are creation of the mind. And then you can see the branding on the car, the name of the company that has manufactured it, okay, and then you can see in this image they've also shown that if you're playing any music in the car, that music has also been created through somebody's idea, through somebody's work, through somebody's intellectual creativity. That itself also is protected as an intellectual property right. Now, what are the different kinds of intellectual property rights? As I said that IPR is a bundle of rights. So if you see, there is a categorization. You can see that we've mentioned trademarks, copyrights, patents, designs, semiconductors, plant varieties, geographical indications, and trade secrets. Now it's very difficult to cover all of these segments in one session because these are all special areas of not only practice but even understanding the law around them. So for this session we've decided to only limit our discussion to trademark, copyright, patent and design. The remaining 4 maybe we can have another session to cover those. But geographical indication I've given you a brief idea already through a way of example. Now if you come to the next page, we will discuss the benefits and importance of IPR. Why is it important to, number 1, recognize IPR, number 2, protect, and number 3, enforce. Okay, so first of all, we have to recognize in one object what is an IP that vests in that. When somebody says that this is my IP, we need to recognize and accept the intellectual property, the creation, the idea, whatever it is. Okay, so now from time immemorial, we have been an innovative society. We have a lot of inventions dating back to centuries in our country. So we are a country of scientists, we are a country of innovators, we have been, we have so many inventions to our credit, right? So that itself brings us to the first reason why we need to protect, because we have centuries of tradition of protecting and, innovating. Number 2, nowadays, we are seeing a culture where, it is important for people to seek appreciation, acceptance, and even acknowledgement, of their works, of their ideas, of their creativity. And you can see more and more people coming out to the forefront to show that this is their creation and this is their idea or this is their innovation. So this fact that we recognize, it stimulates creativity. It stimulates people to create more and more, to innovate more and more when they know that their creativity, their innovation will be accepted, acknowledged and then appreciated. So this becomes a big reason to protect that. Number 3, of course, a big innovation or even a small innovation or a small creation, like even a song these days can go viral, can become a big hit and can generate a big income for people. So a small work can also become a big financial asset for a lot of people. So imagine with a big invention or a big innovation, how much financial boost that can bring to the economy. Then of course number 4, as we discussed, that all of this is necessary to encourage advancement in science and technology, in arts also. So in literary works, in writing, in artistic works, paintings, etc. So these are some of the reasons why we feel that it is important to recognize, acknowledge and protect intellectual property creations of people. Now coming to the first heading of intellectual property, which is trademarks. So most of you must have heard of this term. We say कि इसको trademark करा लो, बड़ी बारी हम ऐसे बोलते हैं कि ये protect करो, इसको trademark कराओ, इसको copyright कराओ, without even technically understanding कि trademark होता क्या है, trademark आप किसको करा सकते हो, जिस चीज को हम बोल रहे हैं कि इसको trademark कराएं, whether that is even whether that can be even protected as a trademark. So to give you a brief idea of what a trademark is, a trademark can be anything. It can be a simple tick mark as we saw. It can be any sign, it can be any name, it can be any logo, any device, anything that can indicate that you can apply it to a particular segment of goods or products or to services also. And that should indicate to the consumers that this belongs to the owner. So most of us have our law offices, right? We are all practicing lawyers. We all have our law offices. We all try to create a small, maybe, a logo for our office or a small name for our office. That name or that logo that you create is to indicate to your clients that the legal services that you are providing are being provided by your office. Okay? So this is the function of a trademark. And that name, that logo, you can register, you can protect as a trademark. So in simple words, to give you a simple example, this is what a trademark is. And it can be anything. It can be a combination of letters also. There is a very famous airlines, KLM. शायद सबने नहीं सुना होगा. KLM है 3 letters का combination है. KLM. It doesn't mean anything, but maybe it has been, this abbreviation has been created out of something. So it is a creation by the owner of KLM Airlines. And now everybody knows कि KLM Airlines किनकी है, सब travelers को पता है. So KLM, just a 3-letter word, is also a big trademark now. It's a big brand. So even 2 letters, and we've seen that Apple device, half-eaten Apple device is also a big brand. So anything that denotes that you are the owner and your consumers can associate that brand with you, that is enough for you to enforce your rights as the owner of that trademark. Okay? Very small information I'd like to share without going too much into detail. हम सबको हमेशा ये लगता है, maybe we have sometimes clients also coming to us and telling us that trademark register कराना ही है, mandatory. लोगों को लगता है mandatory है, but registration in India is not mandatory. India trademark law, there is a specific act protecting trademarks, which is the Trademarks Act of 1999, which repealed the previous act of 1958. At present, we recognize any person who can come forward with some evidence and show to the court that I am using this trademark from such and such year. Registration is not mandatory. It is important, yes, because it is a prima facie proof of your ownership. So when you show a registration certificate to somebody, including in a court of law, the court will automatically believe that you are the owner. But even if you don't have the registration certificate, you can still establish ownership through evidence. But then that becomes a question of trial and not a prima facie proof like a registration certificate is. So sometimes we have clients coming to us when they tell us that we need to register and only then we will use. जब तक register नहीं होगा हम use नहीं करेंगे. Registration are 2 different things. You can use it for many years and still not register it and still be protected. So you start using it, and once there is sufficient evidence, then also we can register it. Sometimes a trademark is weak because trademark law does not protect those words which are common dictionary words. Obviously, we cannot monopolize common dictionary words. Anything to be protected as an intellectual property has to be unique, original, not conflicting with any third-party idea, right? So a brand which is a general dictionary word will have no distinctiveness, will have no unique value. So in those cases, we always advise to not register because it will be refused and that goes against you. But a common dictionary word also, if used for a long period of time, that can still be protected But now a common dictionary word also, the consumers are able to associate that with the product. Like apple, right? Apple is a name of a fruit, but it is not distinctive. But Apple Inc. still owns rights to it. Now, because over a period of time also they have built that reputation that consumers absolutely associate that with iPhone, right? So this is one example. There are many nuances in trademarks law which are very difficult to go into in detail, but this is one tip that I thought we can share with you which will probably help you that when we are advising our clients, we don't have to follow the rule that registration is mandatory and only if you register you can use a brand. That is a misconception under trademarks law. Now coming to copyrights. Now copyright protection again is a protection granted to a bundle of works. There are different category of works that can be protected as a copyright. It could be a book, it could be a painting, it could be a photograph, it could be a software program also. So various things, a sound recording, a movie, all of these things come under the protection of copyright law. And the statute is Copyright Act of 1957. Now this is something I missed mentioning in the beginning, but I'll mention it now, that intellectual property contains within itself a series of special laws. So there is a Trademarks Act, there is Copyright Act, there is Patent Act, there is a special statute for design plant varieties protection. These are all like 7-8 special statutes dealing with each category of intellectual property. So for copyright also, the Copyright Act of 1957 deals with protection and enforcement of all of these works, which is literary work, a dramatic work. A dramatic work could be anything, it could be even a theatre performance, okay? And a cinematograph film, a sound recording, a song, all of these things are protected as a copyright. Coming to patents. Now patents, as most of us know, that it deals with rights granted for an invention, okay? Now unlike trademark, पेटेंट्स में अगर हम पहले से दिखा दें कि हमने अपनी इन्वेंशन कहीं पब्लिश करी है या कहीं पे शेयर करी है, then we cannot get our invention patented. And it has to be absolutely new and novel. We cannot show any prior publication of our invention. Okay? So this is something which is different from trademarks law and under patent law. Now patent, आपको कोई भी innovation है, कोई invention है, उसको patent कराने के लिए, Ma'am Sangeeta Dubey is also here. Please join us, ma'am. So there are three most important elements that we need to keep in mind when we are talking of getting any invention, any innovation patented. Number one, it should be new, as I mentioned. New होना चाहिए, it should not be known to anybody before, कहीं publish नहीं होना चाहिए, because invention पहले theory में हम अपने claims बनाते हैं, वो कहीं पे भी किसी seminar में कहीं पे भी publish नहीं होना चाहिए. Number two, there has to be an inventive step. Now what do we mean by inventive step? Inventive step का ये मतलब है कि आपने जो भी चीज क्रिएट करी है, इनोवेट करी है, उसमें कुछ एक ऑब्वियस एलिमेंट नहीं होना चाहिए. मतलब people should not feel कि अरे ये तो मैं भी कर सकता हूँ. You know, there has to be something new and actual inventive step has to be there. The third thing is that it should have industrial application. So it should not be completely theoretical or academic. Whatever we are inventing, whatever we are speaking of inventing, that should also be applied in industry. We have to show that that is capable of being applied in industry also. उसकी कुछ practical utility होनी चाहिए. So these are the three elements that we need to keep in mind when we say that when we are advising clients, when we are looking at some kind of innovation and we are trying to advise the client whether that can be patented or not. So we can look for these three elements always. Now generally patent law में एक question ये आता है कि this is a very technical subject relating to science and technology, right? We as lawyers are not, we sometimes feel we as lawyers are not scientists. We cannot decide. Even the judges also on some occasions feel like that. So how do patent disputes get decided in a court of law? ना lawyers को पता है invention के बारे में, ना judge को पता है. Then how do we decide? So a very typical trend in patent litigation is that an expert evidence is called for. So if I am a plaintiff in a suit for patent infringement and I am alleging that a third person has infringed my patent, has copied my invention, then I have to obviously make my claims but also supported with an expert evidence, and the defendant will also do that. So there has to be a neutral third party expert evidence called in, which is then evaluated by the court of law. So the judge will not question the expert opinion, but the judge will obviously have the judicial mind and capability to analyze the opinions that are brought before the court and accordingly decide on the matter. So this is a typical trend that we see in how patent disputes are handled, litigation per se. Now coming to the fourth category, that is designers. Now design is something which I gave you an example of with the phone. Something that is appealing to the eye, something that has a visual appeal. It could be a chair also, but a chair which is designed in a way which has some aesthetic value. जैसे हम चंडीगढ़ में रहते हैं, हमने सबने कॉर्बूजियर चेयर्स का डिजाइन देखा है, right? Those chairs are designed with an aesthetic appeal, and hence they are protected under Designs Act. Okay, so anything that has a visual appeal, which has a particular shape or pattern, which can be represented in a 2D or a 3D format, these things can be categorized as a design. So broadly speaking, without going too much into detail regarding law and everything, but of course I hope I could throw some light. So this is broadly, when we talk of intellectual property rights, this is what we mean. And every special act, whether it is a Trademarks Act or a Copyright Act or designs or patent, all of these statutes have their technical requirements under which you can register, protect a trademark, copyright, patent, designs. There are specific elements to be considered, and again how you can enforce those rights also. So broadly speaking, and to keep it short, this is in a nutshell what IPR is. I'm open to any questions if anybody wants to ask anything or discuss anything. Most welcome. Yes sir, पहले सर डिजाइन और पेटेंट एक ही होता था. पहले एक ही स्टैट्यूट होता था, पेटेंट डिजाइन एक्ट होता था. बट इनफैक्ट यूएस में अभी भी डिजाइन पेटेंट का कॉन्सेप्ट है. बट ओवर अ पीरियड ऑफ टाइम, थ्रू हाउ jurisprudence also evolved, when judges also started examining these issues, they felt that they are two separate fields. क्योंकि डिजाइन में कोई इन्वेंटिव स्टेप नहीं होगा, बट पेटेंट में होगा. So there were some similarities but some dissimilarities also. So now they are covered under separate statutes.
Suppose I am designing a cloth, maybe a T-shirt.
Right, sir.
Then that will fall under design.
Sir, a T-shirt could also fall under copyright.
Only designing part.
The design part also, if you are designing it in an artistic way, so then it will depend on the final outcome. So वो किस तरह से निकल के आ रहा है, उसके ऊपर हम, और copyright और design का overlap भी होता है. So again, these are things that depends on what the creation is. Yes, sir.
Question, ma'am.
Yes, sir.
The way you told that there are few words we don't have the monopoly.
Yes.
Can we use any historical monument as a trademark?
Sir, no.
Trademark.
Sir, those are again geographical indications. So they are covered under GIs and they are not covered under trademarks. Yes, sir.
And the practical works can also be bought somewhere registered.
So for example, if you can give me an example.
Nowadays only one word is going of India.
हाँ जी, हाँ जी. So India formative trademarks बहुत मिलते हैं. Like you can add some prefix suffix to it. And you can say, for instance, your name you can add, and like I'll give you an example. We had a client who filed for Gulf Services India. So that was protected as a trademark because उन्होंने एक brand इस तरह से establish किया, बहुत सालों से use कर रहे हैं. So India के formative marks आप फिर भी protect करा सकते हैं, but India as such we can't protect. So proper noun is yes.
If somebody approaches, sorry.
The government can.
So government has a right over वो तो national emblems और उसमें cover हो जाते हैं ये चीज़ें. National symbols.
If somebody approaches you, okay, I want to register a trademark of Big Momos, say, how you will suggest?
So what is the
Big
brand?
Momos.
Big Momos.
Yeah. How you suggest?
So sir, generally I'll share with you how registration works. So when we are talking of specifically trademark registration, the trademarks registry is there in Delhi, Bombay, Ahmedabad, Chennai and Calcutta. तो हम लोग क्या करते हैं, हम पहले डेटाबेस सर्च करते हैं हमेशा. We try and do a search to evaluate if there is any conflict. आप ट्रेडमार्क को दो चीजों पे रिफ्यूज कर सकते हो. एक ग्राउंड है कि उसमें कोई डिस्टिंक्टिवनेस नहीं है. लाइक बिग मोमोज इज नॉट डिस्टिंक्टिव एज सच. एनीबडी कैन से बिग मोमोज, इट हैज नो डिस्टिंक्टिव एलिमेंट टू इट. बट उसको ओवरकम करने का तरीका है अगर आप उसको किसी लोगों के साथ स्टाइलाइज तरीके से बना रहे हैं. दूसरा ओवरकम करने का तरीका ये है कि अगर आप उसको सालों से यूज कर रहे हैं और वाकई में ही अब पब्लिक एसोसिएट करती है बिग मोमोज इनका.
What is the time? सालों से मतलब how many years? Reasonable time.
So generally long is when you can say 5 to 7 years
5
and
to 7
beyond. And sometimes even in a short duration, if you can show that you have captured a huge market share. So there is no rule of thumb. It all depends if you can show how you have captured a huge market share with a non-distinctive brand also. That will also be enough to convince the examiner. The second ground is if there is some conflict with a pre-existing mark. So अगर big momo से मिलता जुलता कोई pre-existing mark होगा, then it is a direct conflict. So then we generally advise to add some elements to your mark to make it little different.
Distinctive.
Yes.
I have a question. Market, there's a common practice to see this one copy, second copy of the big brands,
हाँ जी.
right? And the big companies, they are not bought.
Counterfeit.
I wish to ask that what punishment or what kind of remedy we have against them who are selling these, or it is in a person capacity or any person can
what you're talking of is counterfeits, where these are products which are counterfeits of an original work. And under trademark and copyright, in both you have civil and criminal remedies. You can file an FIR also and initiate criminal action against them also.
Can it be done in an individual capacity or the company whose copyrights are affected only they can do it?
You can, ma'am. And companies भी ये थोड़ा वो है, a lot of companies are also now becoming more and more aware, because now with the internet opening up to everybody, we can see a lot of counterfeits being sold online also. So it is easy to track down, and a lot of these big companies are also taking action. So criminal remedies are also available.
Civil और criminal
इकट्ठे भी चल सकते हैं, दोनों कर सकते हैं। ट्रेडमार्क में सिर्फ ये है कि पुलिस इज रिक्वायर्ड टू टेक एन ओपिनियन फ्रॉम द रजिस्ट्रार ऑफ ट्रेडमार्क्स एंड देन दे कैन इनिशिएट इफ द मार्क इज रजिस्टर्ड। हाँ जी, यस सर, हाँ जी, नो सर, ट्रेडमार्क इज अ टेरिटोरियल राइट। Yes, sir.
I can have my own Apple in India.
Apple has its registrations all across the world, sir.
In case somewhere they are held, then I can have.
You can have, sir, but law इतना evolve हो गया है अब कि हम इंडिया में भी ऐसे cases देख रहे हैं that even if a multinational company does not have registration in India, but if they can show that the public is still aware of the brand, then also the courts are granting injunction. So there are some cases where a multinational company has not taken registration in India, and just like you mentioned, a third party adopted that, got a registration and started using. Then also if the company becomes aware, they can file for an action here, and courts have granted injunction. But उस केस में evidence दिखाना पड़ता है MNC को to establish that they are so popular that even without actual use, the public is still aware that it is a big global brand. So from case to case, sir, it varies. So I hope, it was something useful and open to discussion anytime also. And thank you so much for taking out the time. I know this is lunch time, so thank you everybody.
बहुत बहुत धन्यवाद मैडम जसमीत कौर, एडवोकेट, पंजाब हरियाणा हाईकोर्ट। आज आपने विषय को बड़ा सरल और सहज तरह से पेश किया। मैं अब हमारे बीच में कुछ हमारे एक्स प्रेसिडेंट सत्यवान जी भी उपस्थित हैं, बहुत धन्यवाद है। और हमारे साहब भी है, उनका मैं धन्यवाद